So again, on behalf of the Alabama Center for Dispute Resolution and the Alabama State Bar Dispute Resolution Section, thank you for joining us for today's webinar on anchoring and mediating in the post-COVID era. And at this time, I'll hand the program over to Rod Max and Alan Schreiber, our presenters.
Thank you, Eileen.
Yeah, go ahead, Rod.
Yeah, it's just a real privilege to be joined with Alan and have an opportunity to talk about mediation as it relates to this new era. I think it was in end of February of 2020 where everybody said, what are we going to do now? Courthouses were contemplating closing, juries were not being assembled. How do you resolve a dispute absent the courthouse? Well, mediation was the answer to that, and it has thrived since then and continues today as we continue as here we are on Zoom without the necessity of having to gather together in a room. We miss the handshakes, we miss the camaraderie, but we're able to move the judicial process forward, or at least the opportunity for resolution through dialogue on the screen. But it comes with changes. And so while we're talking about a number of the standard mechanisms of mediation, and you're going to hear from Alan regarding anchoring and me with regard to pre-mediation, it's not in the context of what we had, but it is now revamped as we now have in 2023. And I look forward to sharing this platform with Alan, and I would thereby turn it over to him to gather the next section.
Yeah, so first of all, I wanted to thank Eileen and Tom Corbett with Alabama State Bar, and of course, Eileen with the Center for Dispute for putting on these monthly seminars. And also, Rod, gosh, I just can't believe I'm getting to do a seminar with the father of mediation in Alabama. Personally, I wouldn't be a mediator if it weren't for you. You gave me my first opportunity in the 90s, showing our age, right?
Yeah.
I wanted to tell you how much I appreciate that and have this opportunity to talk with you about several topics. You know, when we were first given this topic of anchoring, we thought the whole seminar would be that. And as Rod and I were talking, we decided to open it up into some other areas. So I hope y'all will appreciate that. But let me step back a minute and just talk about anchoring as a concept. You know, it's another cognitive bias. Many of us are familiar with, say, confirmation bias, where we hear what we want to hear to confirm what we think we know, right? Anchoring is just a context that when people hear a number, like the first number that's put forth in a discussion, often they inadequately adjust themselves from that starting point. So I know I'm backing up a little bit, and I know I'm butchering probably this example, but bear with me a minute. But there were some economists who first documented this whole anchoring bias, and the experiment was kind of interesting, Rod. They took a roulette wheel and they put numbers between 1 and 100 on it, and they assembled people, and they would spin the wheel, and the wheel would land on a number. And then they would ask the participant a question. I think it's a funny question, but they would ask them if the number you're looking at is whether that number is the percent of African nations in the UN. And then they would ask them if it's greater or smaller than that number. And then they would have them make an estimation of what they thought the true number would be, okay? So they spun the wheel and say if the number, what they showed in their science, they spun the wheel and the number 10 showed up, the people would guess that 25% of the UN was comprised of African nations. But when they spun the wheel and the number 65 was the number that they saw, and they had to say whether that was the correct number or not, when guessing the percent, they were at 45%. And through a series of experiments, they were able to clearly show that even though these were random numbers, that it had a dramatic impact on people's judgment, okay? Now, don't take my explanation of that, and you may be going, what the heck is Alan talking about, this roulette wheel? But it's a proven fact that we are impacted by numbers we see, and we know that through car salesmen, real estate agents, and retailers. Okay, they all know this is to be true. So in what we do as litigators, we need to understand that that's a phenomenon, this anchoring bias. And so what that means is you need to spend some time in your putting in your first offer or demand in a case. And what scientists at Harvard, or not scientists, I guess researchers for the Harvard Institute of Negotiation have proven, and they think that it's very well documented that negotiators who put their numbers within what they call the ZOPA, which is the zone of potential agreement, the person that does that first has a competitive advantage. Okay. And so it's important for you to take time to figure out what what a case is worth. And if you have a car wreck, for example, and you have a lawyer and an insurance company that are familiar with the case, everyone could kind of figure out what the zone of this potential agreement is. And we've all seen cases where people have given a demand of $1 million when the case is worth, 25,000 or vice versa, right? So there's real evidence to show that you need to be cognizant that if you're the first one to enter into the reasonable zone, you tend to have this competitive advantage. Well, if that's true too, then how has COVID affected that? And I've talked to several people, and one of the things that's been interesting is, as litigators, we've kind of lost the opportunity to hang out together, right? So when you have a lawsuit, you see each other at depositions, you see each other at the courthouse, you see each other around town. COVID kind of prevented that interaction. But what you were doing, whether you knew it or not, was kind of developing this zone of, if you were talking to Rod about your case and Rod was talking to me about the case, we were kind of developing our own zone of agreement, which kind of enhanced people's ability to get realistic numbers when they started the mediation process. And what lawyers on the defense and plaintiff side have said to me now is that's much more difficult. They don't really know where other side is coming for, so they're having to do more of a one-sided analysis. But what have you seen post-COVID, and what's your comments just about anchoring generally, Rod? And then I wanted to just mention one more thing about it before I let you move on to something else.
Sure. Well, I think the most prominent thing is this: as courthouses opened and gave us an opportunity to start trying cases again, the extremes have set in. Not going to say there aren't defense verdicts, because there are. When there's plaintiff verdicts, they seem to be much higher than what had typically happened. It's a case that would typically resolve at $50,000 to $100,000 is in cases going higher. Let's just say it goes at $500,000, or a $500,000 case goes at $1 million or $1.5 million. And so what's happening is we're going into mediation with demands that are equal to these exaggerated verdicts. Now, these verdicts are still, many of them, some of them may be paid, some of them are on, most of them are on appeal, so they haven't been finalized yet. Some get resolved in post-mediation trial work. But I say that to say that in post-COVID, with courthouses open, we're dealing with demands that may have been much lower before COVID, now are much greater. And it's putting a burden on us to be more active, proactive in the mediation effort, to get to the table meaningfully, and then to stay at the table, even when it either adjourns without a resolution or otherwise impasses. And I'll talk a little more about that when I go into pre-mediation. But Alan, that to me is the biggest challenge that we've got, demands that are much greater, and thereby defense that are saying, well, if they're going to be that high, I'm going to have to be that low.
Right. So that's one of the things that when you read books about, or articles about anchoring, one of the common themes by the writers or researchers are that, you really need to pay attention on how you deal with the other person's anchor. So, and like diffusing the anchor or explaining your position. So if you get, like you're talking about, Rod, this really high demand and you're struggling with it, then, you need the mediator, or you need to be able to explain and articulate why you are diffusing their number, and I give a rationale and explanation for your number. What we see a lot, as you see, is people who react to the numbers and not to their goal, right?
Well, that's exactly right. And, it is about trying to be relevant, and it is also about, while verdicts are out there, we are here for settlement purposes. And yes, the backstop is the courthouse, but that's not just the trial level, it's at the appellate level. And I think in many jurisdictions, Alabama, Florida, and beyond, we are confronted with appellate courts that are perhaps a little more conservative than what's going on in the jury box. And so that too has got to be taken into consideration.
So what were you going to comment on about your pre-suit stuff that you've seen post-COVID, Rod?
Well, and thereby, as a result of this dilemma, and I call it a dilemma, just a challenge for a negotiation process. Are people going to agree? That doesn't begin at the table on the day of mediation. It's got to start ahead of it. And that's why pre-mediation, more than ever before in my world, is something I do every day. I mediate every day. I start around 10 o'clock every day, but at 8:15, 9 o'clock, I'm on the phone talking to people. Now, before I talk to them, I want to review position statements, pleadings, other supporting documentation. That becomes the basis of what the conversation is. And to have that as the mediator, and for the parties, both plaintiff side and defense, to know that we are engaging this, not just to get there and trade numbers, but to understand the facts, to understand the law, to understand the venue, and understand your position on these. Where are we? Are we a week or a month before trial, or are we a year or two before trial? And how to pace this mediation. So reviewing position statements, yes. Then thereafter, go into calls with the attorneys, primarily, to speak with every attorney in the case to make sure we at least understand their perspective. Again, all of it's confidential. None of it is to be shared unless authorized to share it, but to understand the respective and the varying points of view. Sometimes it goes beyond the attorneys, because sometimes somebody says, Rod, I could really use your help in talking with my client, whether that's a plaintiff or a defendant. I've been known to not only talk to them on the phone, talk to them through Zoom. I've been known to go visit them in cases where that visitation says, I care, I'm interested, I want to know. But it can just as easily and efficiently happen by Zoom, as well as even a phone call. So they understand, especially people that aren't familiar with the process, or even an adjuster who may be familiar with the process, but not the setting. It helps bring down the anxiety that otherwise goes into that day. So I take a lot of pride in getting to know the people, the attorneys, the representatives, the clients. And sometimes when I hear from one side and then another side, sometimes it's helpful to bring them together, the attorneys together, before the mediation, just so we have an understanding of what's happening. If we have one of those demands that's going to be extraordinarily high and there's a reason for it, get authority to talk about it, and maybe even join the other side. Maybe you can even begin to talk, and we'll talk more about areas of relevancy or bracketing once we get into the mediation itself. But sometimes the opportunity to do that before the mediation can happen in joint conversations among and between the counsel, orchestrated by you, the mediator. So the activity of the neutral and the activity of the attorneys, the key to a successful mediation is expectations. And it starts with you, the attorneys, and it has to transition to your clients. And if your clients have misexpectations about the day, then we're going to have a problem. But if there's realistic expectations about the day, then you get a chance to lead. Our job is to help you be effective leaders in your rooms. And anything we can do before we get on the screen or in the room, the better we're able to help you. So that, I think, is the extent of what I'd like to say. Alan, did you have anything you'd like to comment on?
Yeah, just on the pre-mediation, two things. One, I see you put on their position statements. I have seen some incredible things done now that I never saw before COVID with pre-mediation statements. I think people have understood that they can put more connections to pictures, videos, medical records, excerpts from depositions, all of the things that we can do now to make the position statements come to life. Also, I think people are more aware that they need to put, not only their strengths, but their weaknesses. That again, I found is why in our pre-mediation caucuses, you can flush out the things that are absent in your position statement, so you can really have a good handle of the real issues before the mediation starts. But I was going to ask you in particular, because I think I've seen it in my practice, is pre-suit mediations. Have you seen more of that, and do you handle those differently? I've just seen, back in the day, you never really saw many pre-suit mediations. Now I seem to get more and more calls on that, and I think you handle those a little different pre-mediation, right? Aren't you more apt to have conference?
Absolutely. And it's a good observation, Alan. And that is, whether by statute, I know in some states, Med-Mal requires pre-suit and discussions, involvement, negotiations, or mediations. But yes, an awful lot, whether it's on the plaintiff side or the defense side, they're asking to get to the table before they start spending the money to litigate. And when that happens, obviously, neither side knows the other side as well as they would have, but for a year's worth plus or minus of discovery or motion practice. So you have a lot of issues out there that could separate the parties, separate the attorneys. But again, coming together before the mediation, as well as at the mediation, there's got to become a pace that's got to be appreciated. Thus, expectations to be reasonable about that pace. If you go to a pre-suit mediation and you can't resolve it, that doesn't mean you dive into a year or two worth of litigation. That just means maybe we need to take an adjournment and find one particular point or the other that will enable the parties to get together. And thereby, the question of exchanging, you can exchange on the screen, you can exchange at the mediation table, but wouldn't it be helpful to exchange before you get there? And that way you know where the other side is going. I've always found that plaintiffs' attorneys that help the defense understand where they're coming from and exchange with them. Now, you can't exchange things that are going to be part of your strategy for trial. I'm not trying to prejudice that. But the more you can share to get the other side to understand, the better able they will be to evaluate it. And I can share examples. I'll do a real quick one. And that's, on the defense side, there's an awful lot of surveillance that goes on. And someone says, I can't work and I can't ride my bike and I can't do all these things. And the next thing you know, there's a camera that's watched all of it. Now, do you share it? Well, not if you're trying the case. You want to zap them in the courtroom. But you know what? If you can resolve that case and you get close enough to be able to say, you know what, you need to take another look at something that would otherwise be kept confidential, it is something that could be shared. But we've got to raise the level of trust. Trust is a big factor in mediation. You start without any, not personally, we all respect one another, but in terms of trusting the process and trusting that the evaluation is going to be fairly negotiated, you don't have that trust to begin with. And so you hold your cards, keep them in your back pocket. But as it evolves, The question is, can you begin to share those things you wouldn't otherwise share? And one of the jobs of the mediator is, when you hear that, the question is, without sharing confidential information, at what point can you encourage that exchange? That becomes a point of interest. That becomes a point of inquiry, and then the question is, at what point in time?
So I know we don't need to belabor this, but it's of interest to me because I've done a lot of these Hurricane Sally claims, and always in those kind of cases, the first party claims, they share their position statements with each other almost always. And then in litigation, a lot of times in tort litigation, it's rarer that you see people actually sharing their pre-mediation statements. I find that it's really helpful for people to share their statements. Of course, you don't have to, but what's your position on sharing mediation statements with each other before they get to the mediation?
In my confirmation letter, I encourage it. And I encourage it as the rule as opposed to the exception. Now, to be honest and pragmatic, most of the time the people don't want to share. But here's the way I handle that. I encourage them to share what can be shared and don't share what can't be shared.
Right.
Give me a confidential addendum that says this is to be mediator eyes only, not to be shared. But in the meantime, that which you can share, two things happen. Number one, the substantive exchange of information, but as importantly, is the fact that you've opened your hand up to the opportunity of sharing, and all of a sudden you raise the level of trust.
Okay. I saw that Eileen went ahead because you probably wondering where we were on our thing, but we are going to go to the Zoom slide. Hey, Eileen, I see 2 people are in the waiting room. Are those 2 people that aren't supposed to be in? Eileen, are you there?
I am here. I just was
Okay.
muted. I just want to let you know, typically, if it's 20 minutes or later, we don't admit
Oh,
people late. It's a
okay, I just saw it on there. So if you'll go to
requirement.
the Zoom slide. So Zoom, let's talk about that. We all have dealt with Zoom, right? That was something that was not pre-COVID, for sure. Although there were some people around the country, I figured out they were doing Zoom that I didn't know about. But just to show y'all how much things have changed. Rod and I both are members of the Academy of Distinguished Neutrals, and Darren Lee did a survey that's hot off the press. Actually, it just came out, and 1,265 of the members of the NADN were surveyed, and over 85% responded. So I would say that's going to be a really good poll. And what we found, this is crazy, is that 63% of the mediations are virtual and 11% are hybrid, and only 26% are in person. That's crazy. And if you look, Darren had put a map of the United States together, and on the map, it showed every state in different colors. And the only states that were lit up in the color like Alabama were Louisiana and Mississippi, where we had a large majority of our mediations all being held in person. Okay. Now, my personal price is they're hybrid, so the definition of virtual or in person is a little bit askew, but I just found that to be super interesting. So all of us need to recognize that Zoom is not going anywhere. They did a survey last year with litigators with the Defense Research Institute and the AAJ, and those polls showed the same thing, Rod, that about 25% are live and 75% are either a hybrid of or full virtual mediation. So we can't escape the fact that Zoom is in our life with respect to mediation. So you need to know how to use it. Right?
Well, you're absolutely right. And what's interesting is, in the world of trust, video wasn't trusted when we began this in, I think, the first week of March of 2020. People said, no, and I recall back to 9/11 when they shut the airports down and nobody was traveling. And all of a sudden you had to go on video, and it was terrible. You could not, you talked over one another because the transmissions were so
Oh,
archaic.
that was terrible. Yeah.
Yeah, but what happened with Zoom is it became not only in vogue by way of the communication, but people didn't have to get on planes. They didn't have to stay in hotels. They didn't have to leave the mediation at 4 o'clock because they have to catch a 6 o'clock flight. They just, all they had to do is go to their kitchen and pull out the chicken or walk the dog. And I called it the domestication of mediation. And it's still in vogue. Not just because of COVID and other health issues, but because companies are finding that why spend the money for all of this transportation and travel when they could use that money for settlement and thereby stay at home, do it and report back. And even when you talk about, well, I gotta go back to the office and get management involved, they've got management at the tip of their fingers. Just make a phone call and you get it done. So
So I was going to give, for purposes of the people here that have signed up, kind of my 5 big things to take away from Zoom in the post-COVID era. And the first is to spend just a little bit, either your staff or you, and make sure your clients know how to use it. And this is particularly important on the plaintiff side. But if you're going to have a Zoom call, make sure that they're comfortable with the platform. Most people have heard of it now. Most people have used it, but take a minute to find out. So the first thing, which seems common sense, but you'd be shocked at how many people don't do this, is just make sure your clients understand the process. And the second is, practice ahead of time. And in particular, if you're going to use breakout rooms, okay? But you can practice with your client or with your other people, and it's really helpful. I know that you and I both have taken classes. Our organizations have given us training, great training, but there's tons of YouTube videos and other things. Even Zoom itself has videos you can watch to get yourself comfortable with. It's very user friendly. If I can do it, anyone can do it. And then actually spend some time preparing your visual aids, like the great feature of screen share where you can actually pop up pictures and documents, but you need to have some preparation in mind when you do those things. And then the fourth thing, there's just 5 I wanted to talk about, was the Zoom settings themselves. Like, make sure the security is on, that you don't record it, your screen share, and again, your breakout rooms. And then the last thing is just make sure that you've got, like Rod and I have, you're centered to your screen and you got good light and you got good sound, and you can really do a lot, man. It's been amazing, hasn't it? The use of Zoom in getting cases resolved.
No question about it. And to take Alan's point into the pre-mediation, because there are some people who haven't used it before, one of the things that could be done in pre-mediation is suggest if it would help to have your client come on the Zoom. Let's see if we can get it up. We'll create a separate invitation. They can meet the mediator. They don't have to meet the mediator, but get them acclimated to it before the Zoom, because again, a lot of anxiety when you get onto mediation day, but you can distill some of that and calm it down with doing that pre-mediation. But no question about it, it is here to stay. I think that real estate needs aren't as great as they were before COVID, but not that it's going to replace it. And there's still a point to being in person. And I'm coming to Alabama next week to be a part of a significant matter in person. But that doesn't mean that that is the norm, at least in the areas where I'm mediating.
So yeah, in Florida, I've actually heard, aren't almost every case is virtually?
It's been amazing. In South Florida, it's 95%. I'm probably the one mediator in my firm that is mediating in person once a week in person somewhere, whether it's in Philadelphia, Pennsylvania, or Los Angeles, or in Orlando. But it is otherwise by Zoom. It's amazing.
So Eileen, you can go to the next. We're talking about just several things about mediation itself. and this is a hot topic too, is the joint sessions. And in the same survey that I just told you that Darren did with the distinguished neutrals, there was also a discussion in there about joint caucuses. And, the trend has been to get away from joint caucuses nationally. The percentages are down. I remember when we would go to these meetings, they would divide the room, the people that thought you should do a joint caucus and those that didn't. In Alabama, one of the few times we didn't do joint caucuses typically, and we would stand with California. That doesn't happen very often, does it, Ron? So, but
Not in
anyway,
California, that's for sure.
yeah. But anyway, at the end of the day, we had a culture here that we didn't do many. We used to do them all the time, and then they kind of stopped. And what I've read in some really recent articles lately is that people need to be more flexible on both sides about use of joint caucuses. I've got friends who will swear to me they'll never do a case without a joint caucus. And I have friends that say they'll do every case with joint caucuses. And what I've kind of mediated with myself is I don't know if it's that black and white about when and how you do it. I do think there's real value in getting everyone together. I do think there's real value in people hearing information at the same time. I do think there's real value in people hearing something from the other side. But I also understand there's certain cases where that's not helpful and it could be a detriment to resolution. So I just feel like we need to, all of us, step back and kind of reconsider. I put in my engagement letters, typically we don't do them. I encourage people to do them, but I also am not going to require it. But I know you being in Florida, what the culture there is and how you react to this whole issue of joint caucuses or just dividing up.
Yeah, needs to be a flexibility with it. When you get into a corporate matter and people are really at angst over a breach of contract, over defective work or employment, where there's a real high level of anxiety and angst one to the other, you tend to not have it. At the same time, I like to encourage it in a situation that the attorneys have talked to their clients, but the opposing counsel has not talked to the client. And if that can be tactfully, meaningfully done, it's really the one opportunity, especially in a typical car accident, the plaintiff's counsel to have the opportunity to talk to the adjuster and give the adjuster their view of it, for the defense counsel to be able to tell the plaintiff, you may have these damages, but there is this thing called contributory negligence. And therefore there's reasons why it's not 100%. And now can that just be given to the mediator and the mediator do it back and forth? Sure. But part of the evaluation is not only the communication substance of it, but the messenger. And I love on behalf of the plaintiff, the plaintiff's attorney, to be able to go in the other room and say, you know what, that was a pretty diplomatic, thorough presentation. And you not only have the facts and law to deal with, you've got a very experienced litigator in the other room. And so too on the defense side, when it can be, and I love on the defense side, the ability to have empathy and objectivity. And when that's done, there can be a raising of the respect, a raising of the trust, and perhaps a changing of the valuation. So I favor joint sessions, but I absolutely respect when it should not be done. And yeah, there's a meaningful percentage that are not.
And if you do a joint session, be sure to be aware of your comments, right?
Yeah.
Like you said, show empathy and show restraint and be sensitive. The next topic we were going to talk about is what you kind of alluded to earlier, are these big verdicts, right? Negotiations with new risk and verdict analysis. So, I'm just always surprised on cases when people don't make themselves aware of recent activity in your venue. Like, you're trying a case in Coleman, you need to be aware that there was a $1.3 million verdict in Coleman not long ago, or if you're in Bessemer, there was 2.3 2 weeks ago over there, or that there were 2 defense verdicts in Jefferson County on a rear end case, and those guys, I just don't think people spend the time that they used to. Maybe it's just because we're not around each other as much. You have to do a little more work to find things out, right? And but it's really what we call the BATNA or the WATNA, which is what you called, I think, when I would work with you, Rod, the best alternative to a negotiated agreement, or the worst alternative. Like what's your best and worst scenario? Well, unless you're aware of these verdicts, how do you give a good risk assessment? We used to have a really good jury verdict reporter that everyone kind of had. Those kind of data points are not as well accessible in my view. So you have to kind of dig around to find out this information. Is that what you're finding too, Rod?
I am, and of course, in the 2.5 years that when the courthouses were closed, there weren't any verdicts coming out.
No,
That may
yeah.
be one of the reasons. But
Yes.
has got to be a reminder is that we're there. It is absolutely fair game and is a great resource. I tell people, I don't need to go to the library. I just need to know what's the verdict ranges out there, because those verdict ranges are important to understand risk. But we are there not to achieve a verdict. We're there to achieve a settlement, and therefore, with the risk factor put into the equation, there's got to be an acknowledgement that verdict ranges are only as helpful as understanding risk, but in terms of achieving a settlement, you've got to evolve to a reasonable settlement range.
Sure. And then that leads to this last part of just the mediation itself is what was the next topic on your slide there, Lane? Yeah, the actual agreement. Again, another thing that's been challenged with not being together is, okay, you've Zoom mediation, you've got people all over the place. What do you do now? You got to have a writing, right? And you've got to be able to figure out how to make sure what you've worked so hard to do as the mediator, and that's get it enforceable in some form of a agreement so that your work is for naught, right? So, obviously people have heard of DocuSign, but some people don't know how to use DocuSign. So you need to plan ahead again, and post. How are you going to memorialize the agreement that you've come to? Now, us as mediators, we were trained that mediators are not practicing law, although we're lawyers a lot. Oftentimes, we're not lawyering the day we mediate. And so when you start writing an agreement, you tend to be leaving one area into the other. So the lawyers have to take control of the settlement agreement process, even though you can assist them, and of course, in getting all that done. But have you just found that DocuSign's better? I know that I personally, when I don't have DocuSign, I've been able to do some email confirmations that tend to work. But I just was curious about your format and what you want to add to people.
It is a little uncertain because some people have DocuSign, some don't. But again, utilizing the video setting and your emails. Number one, and I don't write the agreements as such, but I have standards of paragraph 1 about payment, paragraph 2 about release, paragraph 3 about dismissal. And let them, whether the defense or the plaintiff, fill in the blanks.
Right.
And then the question is getting it back and forth. Yesterday settled one and no one had DocuSign, so it was simply a matter of confirming the mediation. So we actually used a share screen to share the form mediation agreement and then fill it in, let everybody see those terms, and then it was emailed and everybody confirmed that yes, that was acceptable. But it is a little more convoluted than it used to be because we're no longer in the same room together.
And just a tip there, I always, when I do it by email like that, I ask them to confirm not only their, but their client's affirmation to those
Right.
terms. Can
That's right.
be a
That's
little careful. So, but yeah, just a little more challenging sometimes. I do also encourage people who more in the car wreck scenario, but if you have a release, bring it to the mediation. Look, we're all there. I can get the release executed. The plaintiff can get their check quicker. You don't have to go back and forth negotiating terms because you have a mediator on site to work you through the liquidation clause or whatever confidentiality clause you're looking for. So I don't understand why more people don't do that. I think the trend post-COVID is for people to start to bring their releases with them and their closing documents so that mediator can be there to help them get to the final resolution paper and to go ahead and get it executed because it's more efficient. But those are things that you just need to keep in mind when as the process winds down.
And
There we
in
are.
cases
Yeah, go ahead.
in cases that are a little more convoluted, there's the concept of term sheets.
Right.
So it's not just about a number, a release, and a dismissal, but there are terms. Here, an employment case, there may be a confidentiality, non-disparagement, who's getting the money, the taxation of the money, and it is always helpful before that day to create a term sheet. Perhaps, as you said, Alan, create a release or a mediation agreement that tailors to the needs of your client, and then vet it with the other side. That's not to say, you're going to settle, but if we do, these are terms that need to be dealt with and can make the mediation process a little more, put to the point of negotiating only that which needs to be negotiated.
Exactly. Which would be paying the mediator, which people like to raise at the end, or
Yeah.
Having a confidentiality clause, which for a lot of plaintiff attorneys or defense attorneys is a big thing that they just assumed would get handled, which, is not easy. Liquidated damages, another one. So if you're going to have these kind of issues, bring them out at the beginning or before, and and not let that gunk up the resolution.
That's exactly right.
So when you have these cases that linger on, like you can't get to the final resolution, Rod, you and I were talking in preparation of today, and we both commented that the percentage of cases that kind of linger is more, right? I think that there's more post-mediation discussions than I remember pre-COVID. I think you agree with me on that.
Yeah.
So tell me about that, and let's help.
Yeah, it's a product of this.
Yeah.
And I don't want to just center on these large cases, but when you come to a mediation where the value here, I'll take it from low to high, the value is around $100,000, but the demand is $5 million. Or when the value is around $5 million and the demand is $80 million. That's what we're beginning to see. And so what happens, and I mean, I've heard this from the defense, when they go to a mediation where it is just way out of whack, they're not coming to settle the case. They're coming to get relevant. And then that's step one in a two-step process. Let's see if we can get them relevant. And then we'll go into post-mediation.
And you've seen that the other way, not just defense do that, but plaintiff lawyers have done the same thing, right? Like where they think they have a really big case,
Right.
The other side feels like it's not worth anything, then you'll see them show up to try to get some parentheses or some body around their case, right?
That's exactly right. And we talked earlier about, I'm going back into the mediation itself, there are needs for not just bracketing, but I call early in the process, getting areas of relevancy. It's not about 80 million, get down below 10 and we'll get up above 1. Or if the case has a value around 250,000, it's not about being at 5 million. It's being here, get below 750 and, we can get above 100 to see what we can do with that. So it's areas of relevancy, which sometimes are the conclusion of the mediation. So the question becomes, and this is the last screen that we have, is in post-mediation, what goes on in post-mediation? Well, number one, the evaluation process must continue. And with that continuance, what causes reevaluation? Well, discovery, some expert, some inspection, a motion practice, whether it's summary judgment, whether it is motions in limine. Sometimes there are interim appeals that have got to go on. And what this gets to is there's got to be an understood pace. You know, I had a disaster in college when, as the head of my fraternity, I volunteered to run an 800-meter run, and I thought it was a sprint. So I ran around the track once and was done, and I beat everybody until the person in charge said, "No, you got to go again." And I never finished the race because I didn't pace myself. But I say that there's got to be a pace to the mediation. Are we going to this mediation to get it done? Are we going to get it relevant? What is that agenda? And then it's about being able to lead your client, because if your client thinks they're going to settle it by 2-3 o'clock in the afternoon, and you're just beginning to get relevant, and the adjuster in the other room says, "We're not getting there today," all of a sudden you got a client that's upset. But if there's a way to try to set expectations, that doesn't happen. So there are outside events from the mediation that help with the reevaluation. And then the second part of that is that by means of neutralized communications, whether they're emails, calls, or sometimes reconvened session, there are ways to keep the ball in the air. And as the neutral, being committed to resolution, it's not over when that day is over. We pace ourselves. Is there a need for a call or an email a week out, 30 days out, 2 months out? And make it neutralized. It's not provoked by anybody. It's provoked by the mediator who's just interested. And to be honest, in that way, you can cover confidential communications. The communication that says, "Hey, Rod, I think my client's interested now." No problem. Put out a neutralized email. "I just want to know what's going on, what I can do to help." All of a sudden, you provoke the dialogue. Most of the time, you don't have to go back to the table, but sometimes you do. But as long as you can work it by way of phone, email, text, there's so many ways to keep that discussion going. My saying is, as long as there's dialogue, there's opportunity. When there's no dialogue, no opportunity.
Right. So, you know, this whole thing with motion practice too, we see this a lot right before the mediation. The other side drops a motion for summary judgment. You know, of course, we as mediators, I would feel that's the time of uncertainty where things can get done, right? Where risk is enhanced.
Yep.
But sometimes you need to wait for certain rulings or certain depositions or something to happen. But I've done a better job, I think, as a mediator, telling the parties that, yeah, my intentions for the day is to get your case resolved. I've only reserved this day just to work for you. But if we don't get it resolved today, that doesn't mean we can't get it resolved. That you can't get a case settled till you start getting it settled. So the mediation today is a start of that. But I think sometimes if I forget to do that, if I go in later and I tell them, "Oh, we're going to have to adjourn and we didn't get it done, but I'm going to keep working on it," I think the parties sometimes think, "Oh, well, he's just saying that because he couldn't get my case settled." So I say that because if you're on the call here as a mediator, or if you're a party, I think it's really important that you, if the mediator doesn't do it, that you as the attorney be sure that the people that you're representing understand that now post COVID, post mediation follow-ups is way more prevalent than it used to be, in my view.
Agreed on that. And it provokes in my mind one last area, and that is when parties are so far away because, well, we've got this motion for summary judgment and we think we're going to win. Well, you know what? I got an idea. What's the idea? The idea is create a high-low. You win. On the defense side, it's the low. You win on the plaintiff side, or it's overruled, it's the high. But make it so that's the end of the process, and you don't have to go into trial and appeal. High lows work, and they not only work, but sometimes they provoke. Well, if we're going to agree on a high low, why don't we just keep negotiating?
And what's hilarious, have you had this happen where someone's argued all day that the value is either this low or this high, and he's way too high, but then when you start talking about the high low, they have to switch their argument because they don't want the high or the low to be the number that they said it shouldn't be. So
I have some very remarkable high-low experiences. I won't go into them, but high-low is something that works, as are what I call, and Al, I know you are up to do this too. We are asked at times when neither side wants to move, well, could the mediator make a proposal? And as if you've gained, and the beauty of this process, if you've gained the respect and the rapport and the trust of the parties, sometimes, I'm not going to say every time, but sometimes. I mean, I've done them in the last week. I've probably done 3 of them, but I say that, and 2 of them have been mediator brackets, because I realized I couldn't put out a number, but in trying to be irrelevant, and you see my hands on the screen, they're now off the screen because they're not relevant. But if I can get them on the screen, perhaps I can create a bracket to leave the mediation with both parties accepting it. And if they do, then they negotiate within that bracket. So mediator brackets, mediator proposals, and give parties, even adjourning parties, if not done that day, to have a chance to confidentially say yes or no. It's either 2 yeses or 2 nos. The actual response is confidential.
Yeah, and one of the things that you mentioned is brackets thing, and I'm just in my own personal practice, because I've had mentors, and you have different views on brackets, just like you did on joint and caucuses, right? People have the adjusters have preconceived ideas of
Right.
brackets. Like, I'm not going to use bracket till 4 o'clock, or whatever I don't use brackets, whatever their thing is. But I've become more flexible with brackets from where I was trained. And I do think there's oftentimes people forget that sometimes using a bracket early is better. If you don't use it early, you may not even have the opportunity to use that mechanism to share information later. And I think people need to be more flexible in their quote rule about when they utilize brackets, because brackets are nothing more than another way to share information with the other room, right?
That's right. And area, the early bracket, I call area of relevancy, because you're asking, look, I'll be good if you're on the defense side. I'm willing to get above X if you're willing to get below Y. Or from the plaintiff side, you just say, I'll get below the higher number if you'll get above the lower number. But the point of that is, and the part of that communication is, are we signaling the middle or not? Now, if you don't want to say anything, fine. Let the middle be what it is, because people do preserve it. Hey, everybody looks at the middle just as a mathematical tool, but that doesn't necessarily mean something. And if you don't mean it, the key is to say not the middle. That way you don't mislead.
Right. So I think all this kind of sum up here, and I've enjoyed talking to you and to the lawyers that have run through my office the last couple of weeks in preparation for this, is litigation is just different. I mean, since COVID, not just the remote part of it, which we've seen these staggering statistics, but the way you prepare, the way you have to communicate with each other, the way insurance companies are with their own lawyers, and the way they are now more remote. People adjusters that used to be in town are now several states away. So the whole process, the mediation whole process is just dramatically different. And so I hope these pointers were helpful for those people who decided to be on this call.
Well, I've enjoyed the dialogue with you, and I do appreciate the opportunity.
Alan and Rod, I do have a question for you, because you've brought home some good points about follow-on evaluation and communications and the importance of confidentiality. So I'd just like to ask you, in your mediation agreement, when do you define when mediation begins and when mediation ends to protect and preserve the confidentiality of the discussions?
Right. Very good question. For me, confidentiality starts when I am confirmed as the mediator and send out a mediation letter to that extent. Everything I do is confidential. And if need to be stated, it is stated before the mediation, during the mediation, and even after the mediation. Now, sometimes when attorneys have strategies that they do not want confidentiality to interfere with their ability to make statements, then, I shut down confidentiality, and I'm not actually a part of it. But if they re-engage the process, I make sure that every communication I have is a mediation communication, and
So this issue came up locally a couple of years ago. Mediator actually ended the mediation and then had some follow-up conferences. And the court held that those conferences were not mediation because he had sent a bill and concluded the mediation by email. So, yeah, there is kind of a trick there. If you're going to leave mediation open, you need to make sure your communications are clear about that. I always send an email, make sure I'm continuing. I send the judge a letter that says the parties came to my office. We're continuing to discuss the case. And my communications are clear that it's part of a mediation communication, but you can get in trouble if you're not careful about it.
That's right. That's right. Just got to be well defined.
And so, ladies and gentlemen, thank you for joining us. I've put our prisoners' contact information on the screen. So if you have any questions, we're about out of time, but feel free to reach out to Rod and to Alan, and their information is here. You'll be receiving these slides as well as a handout. We've also provided on the next slide some resources available to you, some further articles on the anchoring effect in mediation that has been touched on during today's webinar. And gosh, I feel privileged, Rod and Alan, to have spent the last 60 minutes with you. I've learned so much during this session. So thank you all for presenting on this program today. Any closing thoughts before we adjourn the meeting?
No, I just know that Rod's lucky because when he shuts down, he's in beautiful Florida. Looking at the water.
It is beautiful down
Hey,
here.
Rod, it was so great being with you. I love you, man. Thank you.
Love you as well. Thanks for the opportunity, Eileen. Thanks for all your good work as well.
Oh,
Yes.
you're welcome. It's an honor. And thank you again, everyone, for joining us. We will send you an email with an evaluation link as well as the materials from today's webinar. We hope that you will join us in June at noon as we present another free CLE as part of the Alabama State Bar's Dispute Resolutions Improving Your Mediation Skills series. And hats off to Alan and Tom Corbett, because this is their brainchild to put on these free webinars every month to help mediators improve their skills. We also know that the majority of our audience are attorneys, so we hope that you've learned something as well, hopefully to put in your toolkits as you represent clients during mediation. And with that, I'll go ahead and conclude our webinar. Thank you all.
Thank you so much.
Appreciate it. All the best.
Bye,
Take
everybody.
care.
Have a
Good to
great
see you,
week.
Alan. Enjoyed working with you.